talk, you will push.
Ready? Committee on Education Reform will come to order. Madam Clerk, please call roll.
Mr. Chair.
Here.
Representatives Hornberger, Crawford,
Here.
Garcia,
Present.
Roberts,
Here.
Alexander,
Present.
Griffin,
Here.
Lilly,
Here.
Noble,
Here.
Riley,
Here.
Semke,
Here.
Brinks,
Here.
Chang, Camilleri, Sowerby.
Here.
Mr. Chair, you have 12 members present. You do have a quorum.
Thank you, Madam Chair. We need a motion to adopt the minutes of May 18th, 2017 as printed. Thank you, Representative Lilly. Hearing no objections, the minutes are adopted as printed. Before we get started here, I want just to let everybody know there's clearly a ton of people. This issue has raised a lot of passion on both sides, and we understand that. We think we've got 2 or even 3 overflow rooms. Once we get past initial testimony and we go to public comments, there's so many cards we're going to have to limit it to a minute each. Clearly, there's going to be a lot of redundancy. I would urge you try and not to say the same thing. Have some bit of twist. If you don't think you can say something different, then perhaps refrain and give it and say thanks, but I don't wish to comment. Anyway, we'll try and get through this as quickly and as efficiently as possible. And with that, we'll start with testimony on House Bill 4425, authors Barrett, and House Bill 4426 from Representative Noble. And we'll hear testimony from both representatives, as well as Mike Ross, William Wagner, Aaron Mercino, and Joel Dorfman. So, Representative, please take it away.
Thank you, Mr. Chairman, and thank you, members of the Education Reform Committee, for taking this up. And Mr. Chair, congrats on your pending appointment, and thank you for squeezing us into your busy committee schedule. We really appreciate that opportunity. Joining me at my table are a few attorneys, Mike Ross, Dave Coleman. Professor Wagner's here. Dave Coleman may be joining us, Aaron Mercino, and Joel Dorfman. Behind me and in some of our overflow rooms are moms and dads of real children. They're educated, aware, and fully knowledgeable of the decisions that they make for their families. They stand for the ability to simply parent their children like the laws of our state already allow them to do. While the bills before you are casually referred to as vaccine choice bills, they're actually about parental rights, government overreach, and bureaucratic accountability. Michigan law grants parents the right to waive any and all vaccines for their children for medical, philosophical, or religious reasons. That law remains on the books today. Additionally, our state constitution guarantees the right of a free public education to our children. Yet, an administrative rule that was never passed by a single legislative chamber was put into effect that hinders that constitutional right. A State Department now mandates that parents must take time off of work to attend a re-education class with a public health official, resulting in what many describe as a hostile interaction. Some parents have been harassed regarding their religious beliefs, with bureaucrats challenging them about the specifics of their particular faith and denomination. What government does that to its people? And some parents with multiple children have been required to attend this training separately for each child. Mr. Chairman, I'm pretty sure that the North Koreans only re-educate you once, so I don't think we should do anything greater than they do at the very least. At the end of this training, they coerce parents into signing an incriminating statement to satisfy the bureaucratic requirement to simply send their child to school. I challenge all of you on this committee to ask tough questions and to not shy away from the truth. Ask the folks joining me today to defend their position. Ask the health department if the incriminating waiver statement could be used in a CPS-related matter, or if it could be used in a child custody dispute between adversarial parents. Ask them if a parent today would receive a medical waiver for a younger sibling if the older sibling had an adverse reaction to a particular vaccine. Ask them if any vaccines that are state mandated have been derived from cell lines that have been derived from aborted fetal tissue. The health department will tell you that the vaccine waiver rate declined after these rules went into effect. But you should ask them how much the waiver rate declined the year before these rules went into effect. Spoiler alert, the waiver rate actually declined 24% on its own the year before these rules went into effect, and the waiver rate actually went up in the last year with these rules in place. It would be more convenient to sweep this issue under the rug and silence the assembled parents here today who simply want to codify their parental rights that are paramount to the upbringing of their children. But all of us who serve in office chose to run because we wanted a voice in the legislative process. We came here to represent our districts and craft policies for the state of Michigan. Mr. Chairman, only 3 states require parents to attend a class to exercise their parental rights to waive a vaccine. Michigan, however, is the only state that requires this through administrative rules and not through legislative action. Ultimately, you must ask yourself 3 simple questions. First, do parents have the right to decline vaccines for their children? Second, do we require classes for people to exercise any other fundamental right that is guaranteed to them? And lastly, do bureaucrats make laws in our state, or does the legislature? Because if the bureaucracy can craft their own laws, then we can dissolve the legislature and all of us can go home. You do not have to agree with each parent's decision to vaccinate or not vaccinate their child to believe that it is still their right to decide this for themselves. Children belong to their parents, they do not belong to the health department, and they do not belong to the state of Michigan. And with that, I wanted to turn it over to the other members here with me today to introduce themselves, but I also wanted to briefly mention that this particular administration has been very intent on removing barriers and streamlining operations and making things smoother for people in public, getting your tax return faster, all of these other things, renew things online. And yet with this particular process, they are throwing up burdens for parents who simply want to exercise a fundamental right that they are afforded. So thank you for your consideration again, and welcome the others joining me to introduce themselves.
Good morning, Mr. Chairman. I'm Mike Ross. I'm an attorney licensed in Michigan. I have extensive experience representing parents and individuals who regularly have to deal with these vaccine issues. And more, since these rules that we're talking about went into effect, that's about 80%.
Just speaking in the microphone a little bit.
Since these rules went into effect in January of 2015, an inordinate amount of my practice is devoted to dealing specifically with these rules and the burdens that they put on parents and the challenges and choices they force on parents. These are real-world situations, and I am honored and grateful to be able to address the committee on the proposed bill, which I believe is correctly and legally designed to correct the overreach from the administrative rules that were in effect, put into effect January of 2015. And from background, since 1978, Michigan statutes have mandated public and private schools recognize vaccine waivers that are based on medical, religious, and other beliefs of the parents. That's been in effect since 1978 in this state, and it's worked pretty well. It's balanced the rights of parents and the rights of everyone when it comes to public safety and these choices. It provides, it's a very simple statute. It says, quote, "A child is exempt from this part if a parent, guardian, or person in local parentis of the child presents a written statement to the administrator of the child's school or operator of the group program to the effect that the requirements of this part cannot be met because of religious convictions or other objection to immunization." It's a very simple statute. The statute, if you note, does not require any specific form to be used to exercise the exemption. The statute does not require any education of parents when exercising their non-medical waiver. It certainly doesn't require a certification, and it doesn't involve the local health department at all in the waiver process. What we've been doing since 1978 is simply a parent who wished to exercise a non-medical waiver would simply send a written statement to typically the principal saying, "I'm exempting my child because of religious or other beliefs," and that was enough. This new regulation substantially deviates from that, and it conflicts with the statutory provision by requiring this certification, involving the local health department, requiring this education, which, by the way, is just a one-sided education. The regulation 325.176 sub 12 requires only a statement of the benefits of vaccines and the risk of not vaccinating. It does not require notification or education or anything on contraindications and possible risks of any specific vaccine or vaccines in general. So it's a one-sided education to begin with. And as Representative Barrett correctly said, only 3 other states in the whole country require education as a condition precedent to getting and exercising a waiver. And those states, they do it by legislation, not by regulation. And those states also require that you provide both sides of the story, that you also disclose potential risks with vaccines. So Michigan's an outlier here by virtue of this regulation, sub 12. The other aspect that conflicts with existing statutory law is the additional requirements of 325.175 sub 4. So we make it harder to get and exercise the right to the exemption in the first place, and then once you have it, we make it harder for them to keep it because we impose additional barriers and we allow the local health department and the school officials to exclude students based solely on their vaccination status. That's what subsection 4 does, the new rule. And that conflicts with the statute. We already have protection in the Michigan Public Health Code that allows the school, local health departments to exclude any child who is sick, any child who is a carrier. There's no change in that by this bill. We also have, and have had since 1978, the ability to exclude others, vaccinated or not, who are at risk in the case of an epidemic. What this new rule, subsection 4, does is say you can have just one case of a communicable disease, whether it's subject to a vaccine or not, and use that as a blanket excuse to exclude all unvaccinated students. And that actually is going on in this state. It happened in Lake Orion with the school district there. They relied specifically on 175 sub 4. One case of chickenpox in one school. They gathered information on all of the unvaccinated students, over 20, and subjected them to exclusion for the 21-day exemption period. This involved amazing costs on the part of the school district and even worse costs on the parents and students who had to be excluded and then had to make that coercive choice. Do I keep my kid out for 21 days because even though he's healthy, just because he's unvaccinated, or do I violate my own personal and religious beliefs by getting the vaccine just to get him back into school? And then what happens next year when Johnny gets a vaccine preventable disease? Do I have to go, am I going to face the same coercive conduct? So that's overreach there. The other overreach is from the education questioning the sincerity of religious beliefs of parents. And I think that is pernicious. I think that the Department of Health and Human Services, to implement this new rule on education, put on their website directions for local county health departments on how to respond to specific religious objections. And I can provide that to the committee. But reading it, it is bone-chilling to anyone who has any respect for the separation between church and state and does not want their government evaluating the sincerity of their beliefs, telling them that their religious beliefs are wrong, telling them what their religious beliefs should be. Even asking somebody to explain their religious beliefs at a government office in order to exercise their waiver is amazing, and I can't believe that we're doing that in this state. The other aspect of these rules that is inconsistent with the existing law is that they're unfunded mandates. They do not, there's no provision provided to fund the additional staff and resources to local county health departments to provide the education, additional staff to school districts like Lake Orion who have to go find these students, notify the parents, go through that whole process, and certainly no funding to provide the constitutionally guaranteed public education to a child who was held out of school for 21 days for one case of chickenpox. So all of those reasons are why I think this new bill that the committee is considering, it just corrects that government overreach, that inconsistency with what the law we've had in this state since 1978 has been, and that's why I urge the committee to seriously consider it and adopt it.
Good morning. My name is Erin Morcino, and I'm Senior Legal Counsel with the Great Lakes Justice Center. As an initial matter, I would just like to note that the administrative rule, the exclusion of children from the academic school environment for 21 days, is a violation of Article 8, Section 2 of the Michigan Constitution, which promises a free public education to all students. Secondly, it is a violation of MCL 388.1709, which is the Homebound School Act, that requires educational services for all public school students after being out of the school environment for 5 days. Clearly, 21 days is over 5 days, and schools are not living up to their requirements under the Homebound School Act, which of course then would result in a loss of state funding for schools that do not abide by the terms of the Homebound School Act. I would like to testify today about how the administrative rule violates the First Amendment for at least 2 reasons. The first being that it violates religious freedom, and the second that it violates free speech because it requires compelled speech. The first, religious freedom. This administrative regulation imposes a substantial burden on religious exercise. That means that the state has to show that it is first furthering a compelling interest and that the state is using the least restrictive means to achieve the stated compelling interest. The administrative regulation cannot pass this test because it was created to make the waiver process more restrictive. There is a least restrictive means, and that is the waiver process that was in place prior to this administrative regulation. So it is impossible for this administrative regulation to actually pass this constitutional strict scrutiny test. Looking at substantial burden, the courts have found that requiring teacher certification imposes a substantial burden on free exercise. It's found even that a $1 penalty to parents is a substantial burden of religious exercise, clearly requiring that parents take the day off work, go to be educated at the local health department, involve themselves in an argument truly about if their philosophical objection or their religious objection is actually valid with the employee of the local health department. This imposes a substantial burden on religious freedom. They have to make the appointment. Their child cannot go to school. The child would be withheld if they have an appointment that is past the first day of school. So just having the appointment is not enough. It takes this time process that is additional. They have to obtain the appointment, take the day off work, go sit through this education on health, which has nothing to do with their actual objection. I find it almost comical in the administrative regulation where it says that if you're trying to obtain an objection for non-medical purposes, then you have to go see a person at the local health department. This is like saying if you have a non-legal issue, then you need to go see an attorney. It makes no sense. So clearly holding a child from the academic environment that they are supposed to be able to have access to for free, according to the Michigan Constitution, is also a substantial burden. When you look at least restrictive means, the court asks whether there is a less obtrusive form of regulation available to the state. Clearly there is. There is the waiver process that was in place prior to this administrative regulation. Michigan has truly created a hostile atmosphere here toward religious freedom with this administrative regulation. And I've brought with me what was posted on the Michigan Community Health Department's website. This is a list of directions for employees of the local health departments that ask the employees to subject any parent who has a religious objection to vaccinations to basically an argument to defend their faith. And it's filled with complete factual inaccuracies. So it goes through the different religions. It goes through Judaism. It goes through Christianity. With Christianity, it says that vaccinations using aborted fetal cells is morally acceptable. Well, what a statement by the state to propose that and to then say that someone's views, their religious views, are wrong because the state has decided that using aborted fetal cells is apparently now moral. It's not the state's decision to decide that. It goes through how to argue with someone who is a Muslim and how to rebut what they believe in terms of religious freedom and why they should be vaccinated. So I brought an extra copy if you want to go through this. This was taken off the website after Michigan was sued because they were violating religious freedom through this administrative regulation. So it's certainly creating an atmosphere of hostility and is going directly against what the Michigan Supreme Court has held, that the truth of a person's religious belief is not open to question. It is the person's own personal religious belief. The second constitutional point I would like to make is how this administrative regulation it violates the First Amendment's bar against compelling speech. If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. That is the beautiful statement by the United States Supreme Court describing the freedom that we have to our own free speech. Here, if you take a look at the proposed form here, the form that is currently being used for the administrative regulation, this is alarming. If you look at this form, it requires that a parent who has a philosophical objection to vaccinations, that they then admit the exact opposite of what they believe. That's certainly a violation of compelled speech. It requires that a parent who does not believe that vaccinating their child is the best choice for their child, it requires them to say that they're placing their child at risk for serious illness, or if they contract any sort of illness, then they're at fault because it could have been prevented through vaccination. Well, that's the whole reason why a parent is seeking the waiver, is that they don't believe that it is the best choice, and they believe that they can take care of this without having to be vaccinated, and that vaccinations themselves can pose very serious health consequences to their children. And this, of course, there's substantial material to back up that belief, considering all of the dollars that have been spent out through the federal vaccination court. It is interesting to look at this and see that parents would have to accept this sort of statement of liability, but none of the pharmaceutical companies have any sort of liability because of the creation of the vaccine court. So that goes way too far. That is requiring a parent to adopt a statement where their beliefs are 100% contrary. When you look at the different doctrine, under compelled speech, this would be the same as requiring a student who, under the Constitution, can decide not to stand up and say the Pledge of Allegiance at the beginning of the day. This would require them to sign a waiver saying it would be unpatriotic if I did not stand up and say the Pledge of Allegiance. This is the same sort of compelled speech. Or if a woman decides to have an abortion, that she would be required to sign a form saying, I understand that this is morally objectionable and this is the killing of my child before having an abortion. This is completely, directly the opposite of what the parents believe. And this is absolutely a violation of compelled speech. Thank you very much.
My name's William Wagner. I'm the president of the Great Lakes Justice Center, and you just heard a compelling constitutional argument by our senior legal counsel on the First Amendment issues. I was a contributing author to a book called Vaccine Choice that I recommend to you. It became a #1 Amazon bestseller, and it had people on the far left and on the far right and everybody in between, people from science, people from medicine, people from all over the spectrum on this issue addressing what we are facing here today. But what we are not, everybody at this table, nobody at this table is unconcerned about community health. What we're focused on here, though, and what this legislation is about, is good governance. And not only the exercise of government power, but the limits on the exercise of government power. You just heard compelling arguments of how what is occurring right now in the state of Michigan is interfering with First Amendment rights, various First Amendment rights. The Supreme Court of the United States has also made very clear that just like freedom of speech and the free exercise of religious conscience, the fundamental right of a parent to control the upbringing of their children is likewise a very high constitutional right. In other words, that's a very high limitation on the exercise of government power here. And in very clear fashion, you've already begun to hear the abuses of government power that is going on here. Now, do we believe that in the heart of these folks that are engaging in this abuse of power, that they actually are in their mind thinking, oh, I'm going to go get that Christian, or I'm going to go make sure that this person. No, we don't think there's any malignant hate there, but you know what? There certainly is a lot of ignorance. And it's time that we restore good governance under the rule of law in various aspects of our state and our country's governance. And this is an issue that we have to face, because if parents no longer, have that right, and the children now become the children of the state, and the state gets to make all these decisions with regard to the medical health of the child or the education of the child, we've slipped to a place where we certainly didn't start envision in this nation. The fundamental right of a parent to control the upbringing of a child with regard to this requires that same high level of scrutiny of any government action that Aaron was just talking about. There has to be a very compelling reason to come in and do an intense cross-examination that the Supreme Court of the United States has over and over and over again said is unconstitutional. And beyond that compelling reason, which we're not even near the level of compelling, it's got to be the least restrictive means. And if this state can't find a less restrictive means, just like all 49 of the other states of this country have, then shame on us. I know we can do better than this. I know we can do better than this. The state of Michigan, beyond the United States Supreme Court, has enacted a statute to specifically tell the government of the state of Michigan that if you are doing anything, if you are exercising power in any way, just like we are here, you have to do so with recognition of that fundamental right of a parent to control the upbringing of the child, and you have to be able to come forward with a compelling reason, and you have to use the least restrictive means possible in implementing it. That is not occurring here, and that's why this legislation is being proposed. So thank you for introducing it.
My name is Joel Dorfman, and I'm a member of Michigan for Vaccine Choice. I'm here today speaking for thousands of families across Michigan negatively affected by these 2014 regulations. We are not anti-vaccine. We are pro-parental choice, and we are strongly supportive of this legislation. As parents, we've had serious issues with forced education appointments aimed at challenging our medical decisions for our children, whether they be philosophical or religious. We have serious issues with being forced to sign an inflammatory and incriminating waiver form, which implies we are making a decision that may harm our children or the community at large. These forms are required to be signed by parents, and they cannot be altered, even though they disagree with the content, a direct violation of our right to freedom of speech. Parents are signing these under duress in order that their children may attend school, which is their right under the state constitution. Children with immunization waivers are often characterized as a threat to the health of other children in the population at large. It is totally disingenuous to characterize them that way. If you miss a single vaccine, one dose of a vaccine, or you delay receiving a vaccine on the schedule provided by the state, you are required to get a waiver. If you have actual immunity, for example, you have had the chicken pox and you don't need the vaccine, you need a waiver. Less than 1% of our children in this state receive no vaccines. Waivers do not tell you anything about vaccination status. Waiver rates were around 2 to 3% before 2010, the year that the MDHHS added 3 new vaccines to the list of mandated vaccines, and that caused the waiver rates to shoot up to over 10% in that year. MDHHS has pointed to this as a problem when it is not, and in fact it was caused solely by their change in the required vaccine schedule. Waivers declined after 2010 once the implementation and awareness of these new mandates became known by pediatricians and parents. The year before these regulations went into effect, there was a 24% decrease in waivers, about 5,000 fewer, without parents having to be educated by the state. You should also know that even when waiver rates were 10% in 2010, according to the Center for Disease Control data, we had over 95% vaccination coverage for most standard diseases like measles and pertussis. There was hardly a problem that required such a radical change. Keep something else in mind today when you hear about Michigan's ranking compared to other states. Michigan has very stringent vaccine requirements compared to others. For example, some states do not require pertussis. Some require less than 5 doses of the DTaP vaccine. Some states don't require hepatitis B. Some states only require 1 varicella, and some don't require varicella at all, which is the chickenpox vaccine. Other states do not mandate a meningitis vaccine. Michigan requires all of these. Michigan has a population of approximately 10 million. 1.5 million are students. About 500,000 incidents of communicable diseases are reported to the health department every year. Vaccine-targeted illnesses account for only 0.4% of these diseases, and less than 0.1% of children are affected by them. Many of the vaccine-targeted illnesses occur in vaccinated children and adults. That's especially true of whooping cough and chickenpox. For example, 70% of whooping cough cases in this state occur in vaccinated individuals. Please understand that being vaccinated does not mean you are immune from getting the vaccine-targeted disease. And being unvaccinated for the disease does not mean you will spread or contract the disease. We expect and we respect honesty and transparency, especially in our state agencies. The education purportedly provided by county health departments does not provide balanced information, leaving out information on the risks of vaccination, which violates the principles of informed consent. Information provided by MDHHS about outbreaks and diseases that occur in Michigan often don't give the full story. Information obtained through the Freedom of Information Act has shown the following. The Traverse City outbreak of whooping cough in 2014 was publicly blamed on unvaccinated children in schools and higher waiver rates. Yet health department data actually shows that 83% of the children who contracted pertussis were vaccinated, many receiving the series within the last year, and the first person to experience the symptoms of the disease was also vaccinated. There was no mention of the outbreak in Allegan County in November of 2014, where there were over 20 cases of children with whooping cough. Every single one of those children had been vaccinated with a minimum of 5 doses of the DTaP vaccine. In addition, the Allegan County waiver rate that year was very low at 1.8%. This clearly demonstrates once again the false impression given by MDHHS that high waiver rates mean greater risk and rates of disease. There is, in fact, little correlation between the incidence of high waiver rates and high rates of vaccine-targeted disease. Recently, many of you voted for HB 4205, which was a bill that would limit unelected bureaucrats in creating regulations that are more stringent than federal regulations. How does this not apply to regulations that are more stringent than state law? That bill was supported by many of you on this committee. In conclusion, in my opinion, these regulations have little to do with controlling disease and were a solution in search of a problem. They are punitive in nature, and they deny children and parents the rights they are entitled to by law. They create unnecessary hurdles for parents to exercise their statutory rights. MDHHS changed state law through a flawed rulemaking process because I believe they knew they could never get it through the legislature. Last time I looked, it was legislators that legislated our laws, not government bureaucracies. Please support these 2 pieces of legislation that simply rescind rules that, if necessary, should have been implemented through our legislative process. Thank you.
Thank you, Representative Noble.
Thank you, Mr. Chairman, and thank you, committee, for coming in and being a part of this. Obviously, you all have given excellent information. And I don't want to add much, just other than the fact I appreciate Representative Barrett allowing me to come alongside of him with 4225 and 4425 and 4426. Again, we just want to emphasize, and I know it's been emphasized 5 times, this is about parental rights. And I came to Lansing after a 25-year career of ministry to come and help individual rights, and parental rights are the ones that seem to be taking such a beating these days. So that's why we've come here, is to emphasize and encourage that we do things to allow parents to make wise decisions and not have the government make them for them. So that's all I'd like to say. Thank you, Mr. Chairman.
Thank you, Representative Garcia.
Thank you very much. So many of you are new to this committee. We always take the lens and look through the lens of every child in the state of Michigan and not certain populations of children. And we support parental choice all the time in here in deciding educational options and choice. And so I don't think anybody is opposed to parental choice. What I'm concerned about are some of the statements that I just heard through testimony, like 1 case of chicken pox is not a big deal, essentially. Well, for a child who is undergoing chemo treatment or has had a transplant or has an autoimmune deficiency, 1 case of chickenpox could be devastating. So I just encourage you, as you are providing testimony, to remember that it is our responsibility to protect all children. And I understand the concern with the form. I do. And I think that we could probably have some conversation around that. But it is our responsibility to protect every single child in our schools, and it's not just certain populations of children. And I want to prevent us from making blanket statements like some of the statements that I heard. And I don't think anybody is disputing religious belief, personal choice, but we want to make sure we're protecting every student that we have here in the state of Michigan. Thank you.
Mr. Chair, may I respond? Representative, would you characterize your position then that parents should not have the option to decline the chickenpox vaccine?
I'm not stating a position here. I'm just asking everybody, when they're making statements about whooping cough or making statements about whether a child is vaccinated or not vaccinated, it impacts children who are severely
But
ill.
my point is that parents have this right presently, and If they do.
Correct. Is anybody being denied that right? I think what I'm hearing
an
is that it's the
encumbrance on that
process.
right.
It's the process, right? That's what I'm hearing, at least from testimony.
It's encumbering that right of a parent right now, presently, through administrative rule, not through legislative action. Now, I believe that if this legislative body feels that these are compelling rules to create, then it should be vetted through the legislative process, not through the administrative rule process. If the health department feels there's a compelling interest in creating these rules, they should take it to us as the legislature to create, not do it on their own.
Sure. So then I do have another question. So if we take the ability from the local health departments to make decisions, who have more expertise than our local school administrators and teachers, you're actually shifting liability onto the schools. Has there been any thought given to that? They would then have to make a decision individually. Would you support?
I guess I don't understand how would schools be liable.
Well, so the way I understand the bill is that you would prohibit the department from making decisions on defining or putting a statement out there saying that there is an outbreak, let's say, of chickenpox or whooping cough. And so if they can't do it, then the school district would then have to make a determination if they have 30 students with whooping cough, let's say, or 20 in Allegan or in other places, you're shifting the liability to the school. Or am I understanding that incorrectly?
I believe you are understanding that incorrectly. The Public Health Code allows public health officials to take action where necessary to control outbreaks, and the bill itself says that it doesn't apply in the case of an epidemic. I believe that your interpretation
But aren't
of
the health departments determining what an epidemic is?
They are, and the Public Health Code presently allows them that, but again, it should be given or done or performed in the least restrictive way possible, so that, again, in the case of perhaps one instance of chickenpox, we're not preventing people from traveling and communicating with one another.
I would encourage you to talk to some local school officials who
I've
share
talked
the
to-
same concern that I have. I have students, and as I'm sure everybody on this panel does, who have students with very sick children.
Sure, I don't
And they have
dispute
to miss
that at all.
school, and any sort of an outbreak of chickenpox, let's say, could be
But again,
detrimental to
if-
those students. I'm not trying to get into a debate here.
Okay.
I'm encouraging you to have those conversations. And again, the lens that we typically look at here in this committee, and we always, no matter what the debate is, whether we agree or disagree, is to look at it from the perspective of every single child who lives here in Michigan who goes to school. Thank you.
Representative Hornberger.
Sorry about that. And thank you for your testimony today. My question was, as a teacher, I came out of the classroom, and I taught elementary for 20 years, K through 5 every day. A child can be vaccinated, it's my understanding, and you brought it up, and they can still contract chickenpox.
That's correct.
Okay.
And they can also spread that illness when they have been vaccinated.
After they've
And that's
been
why
vaccinated.
people tell you if you have a child that's been
compromised
vaccinated for
immunity.
measles or for vaccines, you're not supposed to even go around pregnant women. Well, honestly, nobody abides by that.
Right.
And time and again, kids that are vaccinated go to school, exhibit the disease after being vaccinated, and then everybody else gets sent home.
So
that are
it
perfectly
is
healthy.
possible for students to be vaccinated and then contract,
Absolutely,
even years later?
absolutely.
Okay, because, and that was something that I witnessed as an elementary teacher. You know, we would have an outbreak of chickenpox, and parents would be confused because my child was vaccinated. It was usually a milder case, but it would happen every year. So I don't know how you, I'll leave it at that. But thank you, and thank you for the data that you brought with you, because it does
You're
help
welcome.
make it less.
Yeah, thank you.
Representative Brinks.
Thank you, Mr. Chair. My question is for you, Representative Barrett. I know we've had some folks who've had, certainly from their perspective, negative experiences with that appointment. And we can argue about sort of the best practices or process for communicating the desired information to parents. But to me, the real issue, the underlying issue here is I'm wondering how, as representatives of all the people in our state, we balance this the rights of the overwhelming majority of the people we serve to be free from vaccine-preventable illnesses, with the desire for that 4 or 5% possibly to have to be free from the inconvenience of that. And I guess I would say, you talked a lot about individual rights and defending those rights, but medically fragile children and other people throughout our state, that number is approximately 6% from what I can tell. And so it's a real similar kind of group of people in the population that we represent in terms of numbers. And they have individual rights as well. And they have the right to be free from disease. They also have a right to go get an education. So to me, we're picking and choosing when it comes to that. Two very small minorities on individual rights. But I guess primarily, I'm more concerned about the overwhelming majority and the health and well-being of our population. So that's my first question is there any level of inconvenience that's worth the balancing that right of the majority?
Well, certainly I would hope we would agree that the inconvenience that's presented presently is an overreach. And we can have a discussion about what should be compelled by an individual seeking to exercise this right. And again, I guess I would challenge you, if you have a paramount concern of an immunocompromised individual, perhaps your solution is to eliminate the exemption altogether. And I don't think that's what this legislative body would allow.
Rep. Barrett, if I might, I ask you to acknowledge that nobody has suggested removing the exemption altogether or the waiver altogether. And it's not in the rule, and it hasn't been proposed in legislation, nor has anybody here,
But there
to
have
my
been other
knowledge,
states to do that.
that have said we will not allow a waiver. And I would
Yes.
fight for folks to be able to have that right to sign a waiver.
And I guess what you and I are perhaps disagreeing on is if you have the waiver, is it the role of government to make it as inconvenient as possible for you to exercise that waiver?
We're arguing in essence about the process being imperfect rather than the right to either have a waiver or to be free from exposure to vaccine.
I think that was the whole purpose of the legislation. We're not relitigating the right.
Yeah.
But it's about the overreach, or what some of us would believe was an overreach by the administration.
Certainly, Mr. Chair, if I may just finally say
Perhaps
one statement,
Representative-
if I can. We've heard a couple of times that people are trying to remove the choice. We hear the very name of the organization, Parents for Vaccine Choice. Nobody is trying to remove that choice. It is inconvenient, yes, I'll acknowledge that. But nobody is trying to remove that choice, not in statute, not in rule. Is that true? Would you acknowledge that in statute and in rule, neither has been proposed?
I would acknowledge that as statute, yes, presently parents are afforded this right, which is why this rule goes beyond what the statute permits. That is why I have presented this bill, and I would go further to say that if you feel that there should be an impediment to parents seeking this exemption, then I think the remedy for that is through the legislative process, not through the rulemaking process. If that is your position, I would encourage you to draft legislation to address that, but we should not cede that authority over to an unelected body to make those decisions. Because today it's about vaccines, and maybe you agree with the rules they've created, but tomorrow it could be about a fundamental right that you believe is important that they've overreached, and not through the legislative process. I am very protective of our roles and responsibilities as a legislature. You and I both represent marginal districts, and we go out and work hard every day to represent our constituency. They have a right to know that the decisions we make affect them each and every day. If they have an issue or a problem with either one of us, they can confront us about that. You cannot confront your bureaucracy about that. They are insulated from the will of the people to have that decision corrected.
Right. Thank you for your response.
Representative Sowerby?
Thank you, Mr. Chairman, and thank you, Representative Barrett, for your testimony and those persons you brought with you today. Medical research has proven that if unvaccinated, 1 in 20 children get complications from measles, including hearing loss and brain damage, with 2 in 1,000 dying. Measles rate has doubled from 2000 to 2007, reflecting the increase in non-vaccination rates. Pertussis, whooping cough, is especially deadly in infants younger than 1 year old, with up to 40% dying. If infected, complications or hospitalization, pneumonia, or brain damage occurs. Pertussis, once thought to be eradicated, is now resurgent. In 2014, prior to the current law requiring local health department visits, the unvaccinated rate was 6.3%. 2 years later, with the same law in place, the rate has been reduced to 3.3%. That's a significant drop of over 18,000 children not being vaccinated.
And I believe it was 20-some thousand that were declined the year before it went into effect. It was a full 24% reduction the year before the administrative rule went into effect.
Can I finish,
So-
please? I'll certainly.
I just wanted
wanna
to acknowledge that
Let me
point.
finish, and then,
Sure.
certainly I would, appreciate your response. The other thing is pediatricians have commented that many parents change their mind when told that the doctor cannot sign that non-medical waiver based on philosophical waiver, that they have to go to the health department. This indicates that it was a matter of convenience in not having to stick to the vaccination timeline rather than a deeply held conviction. High vaccination rates are necessary for herd immunity. This means that those who cannot be immunized for medical reasons, poor immune systems, cancer, or leukemia, are protected by having almost everyone else vaccinated, keeping disease spread low. There is absolutely no proven medical research that vaccinations cause things like autism or other widespread complications. The researcher, Dr. Andrew Wakefield, was thoroughly debunked. His research was expunged from medical research. He was fired from his university, but he continues to speak worldwide on the circuit to spread his false story about a cause and effect of vaccinations leading to autism. I received a letter from my health director in Macomb County, Bill Rodella. He's the director, who stated that Macomb County has an excellent waiver education program and has received no complaints from those who have gone through the program. They offer very flexible hours any day of the week for folks to be able to come and request the waiver. Waiver rates have decreased since implementing the program. The lines in the bill about limiting the power to exclude kids would be extremely detrimental to the public health system. And he has confirmed numerous cases of measles increasing in Macomb County, as well as increased coughing rates. My question to you, Representative, is do you believe that there is a cause and effect of children receiving the vaccination that results in an effect of, say, autism?
You know, Representative, I'm not here to give you medical advice. I'm a politician. I'm not a doctor. So I'm not here to give you research advice or medical advice. That's not the role that I have. My role is to protect the exemption that exists in current statute and protects the rights that parents have presently. I guess I would challenge you, would you agree that parents have this right presently under statute?
Right now, parents have the right to go to the health department and request the waiver as outlined.
Actually,
in
the
law.
statute does not call for them to go to the health department in the reading of the statute. And you're a well-read representative, and I appreciate that. You know, I will acknowledge that prior to your term here, we had a representative who was intent on inoculating the herd, and he was rather disgraced. But that aside, the issue of you know, herd immunity and everything else, I'm certainly sensitive to that. However, I think the testimony that you've heard today would suggest that we have a high vaccination rate in our state right now. And the waiver rate that you're describing had already come down substantially prior to these rules being imposed. So, you know, I don't know if the correlation and causation are exactly what you're describing, that the rule went into effect and that caused the rate to come down. The rate had already decreased significantly, and with this rule in effect presently, the rate has gone up the last year since this rule has been in effect. So it's gone both ways. It went down before the rule was put into effect, it went down after the rule's been in effect, and then it went up again after the rule's been in effect. So I would challenge you on the actual, you know, results of that. So
And the healthcare community, medical researchers, doctors, and health departments all across the state have felt that the current system works. Do you know of any healthcare organizations that support your bill?
I know of parents and individuals who want to seek
I asked
the...
healthcare.
and
Do you know of
again,
any healthcare
I'm-
organizations that support your
I
bill?
don't think that our rights are determinative by the opinion of a healthcare individual. I think our rights that are in statute are protected with or without the approval of a health department official.
Thank you, Mr. Chairman.
Representative Roberts?
Thank you, Mr. Chairman. Just want a few clarifications here, Representative Barrett. One, are cases of communicable diseases on the rise or on the decline right now in the state of Michigan?
I'm not, I mean, each disease would be different, so I don't know by heart
Just-
every single communicable
just
disease.
Let's say measles, let's say pertussis.
And some of those have occurred in people who've been immunized.
I'm not asking that. Are they on the rise or on the decline?
Again, I don't know every single communicable disease and the rates that have come
Okay,
up or
so
down.
no answer.
I gave you an answer. I gave you the answer that I'm not sure that every single disease I don't have by heart.
The next thing that I
That is
have
an answer.
is this isn't necessarily just about the waiver. This isn't denying the waiver right now doesn't deny anybody the right to waive their vaccine choice, correct?
Say that again.
So the situation we have right now with the waiver process does not deny anybody the right.
It's
to-
an impediment that
to
goes
have-
beyond what the statute allows.
But it doesn't deny their right.
It's an impediment that goes beyond what the statute allows.
But it does not deny their right, correct?
Again, it goes beyond what the statute permits through an administrative rule.
The other thing with the elimination of your administrative rules here in your bill, one issue is that this isn't just about the waiver. This is also about medical professionals and health department officials being able to restrict kids from attending school when there's a known outbreak in place. You were saying that the parents' knowledge of the outbreak or the parents' knowledge of the disease is better than what the health officials would be after there's an outbreak occurred. Is that correct?
I didn't understand that. Say that again.
The health, I obviously did you read the entire rule that you were eliminating?
Okay,
I mean, that's-
I'm asking you to
the
restate
issue
your
is,
question.
The issue is that the rule that you are eliminating does not makes it the rule that is in place right now allows health officials and doctors, when an outbreak occurs, to withhold children that may be immunocompromised, maybe are not vaccinated, or just all children in general, close a school for a period of time to be held out of school. Now, without the elimination of this rule, they would no longer have that power.
Well, the public health code would still allow that, but it does not. One of the concerns is that, again, if you have a single instance in the 8th grade of a child who came with chickenpox and an unvaccinated child in the 1st grade could be sent home for up to 3 weeks by the school with no indication that that child has the symptoms or the disease. And I think there's a bit of a misperception, perhaps, that a child who does not have a vaccine is somehow, just rolling around spreading disease. I don't think that's the case. And I don't think that parents should be against their will. They can make that decision. If there's a child that came with chickenpox and your child does not have the full vaccination schedule for chickenpox, you can make a decision about whether or not you want to send your child to school. Certainly send the child with the symptoms home, but a child who doesn't have symptoms, preventatively sending them home, I think is an overreach of this.
But the elimination of the rule, you wouldn't be able to send that child home.
The sick child you would. The child who's not immunized for chickenpox, I think the parents should have that right to decide whether or not they send their child to school.
So you believe that, so let's start with you said the parents have a right. When do the parents that have a choice, their rights that have this waiver, trump the parents that don't have a choice, the immunocompromised students? And how do we balance that going forward? Because there are parents out there with children who don't have the choice to get vaccinated. And you're right now trying to make it easier for parents who do have the choice to trump the rights of the parents that
No,
do
I'm
not
trying
have
to
the choice.
not make it easier. I'm trying to make it exactly what the statute permits. So it's not an issue of making it easier. It's an issue of returning it to the way that the legislation states. If you feel otherwise, again, I would suggest that the remedy for that is the legislative process, not the rulemaking process.
This doesn't change whether they have the right or not. These bills do not do that. All they do is make sure that you don't have to go to the health department to be educated, and you can't keep kids out that don't have vaccination out of school.
Right. Again, the
The rights
administrative
are still there, correct?
the administrative rule goes beyond what the statute allows, Representative. That's the whole point of this legislation.
We have administrative rules for almost every department
Absolutely we do.
Every statute, we allow administrative rules to occur. There's public comment periods on these administrative rules. It's a very long process. This wasn't just.
And again, why is Michigan then the only state that did this through administrative rules and not through legislative process?
We are, I believe, one of the only states that allows a conscientious objection also, not, most states
not
allow
true.
a religious objection. What other
Several
states?
other states, 18 other states allow a philosophical exemption.
Okay. Well, thank you.
Thank you.
Representative Chang?
Just, Mr. Chairman, I have an insurance committee across the hall that I will have to depart at some point to attend for votes.
Representative Chang?
Thank you so much, Mr. Chair, and thank you to those who testified. I had a couple of questions just about the constitutionality arguments that you were bringing up, and I appreciate you bringing some of the arguments about substantial burden and all of those things. You know, I'm just curious because it seems that actually the courts have been pretty clear, I think. You know, I'm just reading a decision from Prince versus Massachusetts from 1944 that explained that a parent cannot claim freedom from compulsory vaccination for the child more than for himself on religious grounds. The right to practice religion freely does not include liberty to expose the community or the child to communicable disease or the latter to ill health or death. And goes on to say that the family itself is not beyond regulation in the public interest as against a claim of religious liberty. And neither the rights of a religion nor the rights of parenthood are beyond limitation. These rights do not include the right to expose the community or the child to communicable disease or the latter to ill health or death. So, you know, the fact that actually we even have exemptions in the state of Michigan says that we're going above and beyond what is required by the Constitution. Is just my reading at a quick glance. And so I guess I'm wondering why you think that if we're going above and beyond now, I feel like we are actually, because we're doing more than is required, why are you now trying to limit it even more? And then I have a follow-up after that.
Representative Chang, thank you very much for that question. I'm very familiar with Prince versus Massachusetts, and also I'm sure you're familiar with the federal RFRA statute passed in 1993, and then Michigan's adoption of the standard from RFRA in 1993 as well, and the strict scrutiny constitutional test that requires when a religious exercise is substantially burdened that the state then must show that there is a compelling interest and that the state is using the least restrictive means to achieve that compelling interest. Here, the statute that is in place is actually the least restrictive means, in my opinion, which only requires the parent to achieve the waiver process through the school directly. This administrative regulation would be then a burden that is unconstitutional because it is not the least restrictive means. So it requires more than the test. It's beyond. It's an additional step that does not achieve the least restrictive means.
So I guess a follow-up question, if that's okay, is it least restrictive means, but also we need to accommodate for the government's responsibility to the public health of our community?
That would be the compelling interest portion of the test and not the least restrictive means. So if the court were to find that there is a compelling interest to vaccinate children, then you would have to go to the least restrictive means portion, and that is where I believe it clearly fails because there is a least restrictive means that is part of Michigan law currently.
And if I might add, we don't disagree with those cases. I mean, we care about the public health and the community, and we look at it that way. But the way that good governance works and the way that our constitutional system works is that when you exercise power, you have to pay attention to these rights, and you have to have a compelling interest. And sometimes there may be a compelling interest. If there was a disease out there that was going to result in 90% of Lansing, dying, within 30 days if we didn't get everybody vaccinated, there'd be a compelling interest. If there's another vaccine out there that is going to be only connected to and only transmitted through sexual activity, and people aren't engaging in the sexual activity, well, there's not a compelling interest there to compel them to have that vaccine. And you're always weighing both sides on this. Somebody earlier talked about causation. The parent is going to listen to all that data that he had, but then they're also going to listen and they're going to see that the pharmaceutical companies put together a fund, and they got Congress to put a fund together because they know X number of people are going to die when they take this vaccine. X number of people are going to be adversely affected, and they know that those people are going to file lawsuits, and so for an exchange of immunity, they've got a fund out there now that's been enacted into law at the federal government. Well, parents are allowed to look at his data, and they're allowed to look at this other data and make these decisions. Yes, should government look at everybody's interest? Absolutely. But if they're going to invade and interfere with constitutional rights, whether they're abortion rights or First Amendment free speech rights or free exercise of religious conscience rights or fundamental right of parent rights, they've got to comply with the Constitution when they do so. And I think that is what the representatives' intent in introducing this legislation. I hope that helps.
Okay, I know there's lots of other questions, so maybe we can continue later, offline.
Thank you, Representative Griffin.
Thank you. I think that my question partially was answered a few minutes ago, thanks to Rep. Roberts, but so I'll provide a little bit of a different twist on it. There's a lot of discussion today, and I have kids too, and I'm a teacher, and so I certainly sympathize with the high emotional tone of today, right? But I just want to be clear, and I want to clarify that parents still have the right to opt out with the waiver. That's not going to change. Correct? Okay. And how many other states currently have the waiver in the same way that we do? Same way? None. Nobody?
3, but it was through legislative,
Okay.
legislative, they said. Only 3 states.
No, the waiver is different than taking a class. The philosophical exemption?
The philosophical exemption. Did I hear 18?
16.
So 18 other states, yeah. Thank you for the clarification. So 18 other states currently allow the philosophical exemption as well, right? So parents still have the right to opt out with the waiver, correct? Okay. Thank you.
Representative Lilly.
Thank you, Mr. Chair. There's been a concern raised in some of the panel testimony here regarding the specific language of the acknowledgement statement on the form. I've had the opportunity to review the form, but despite the massive amount of documentation that we've gotten for this hearing, I think it's more than I've ever seen for any other hearing. But I will say I did go through all of it and didn't see a copy of the sample form in there. I did see a copy of at least one floating around on the table, and I'm wondering if for the other members of the committee that haven't had a chance to see that specific statement, if it might be helpful for them to look at. So, thank you. Yeah.
We'll have copies made.
You want to hand it to me, and I'll have it run.
Representative, is that?
Yes,
Okay.
yes, thank you.
Representative Crawford.
Thank you, Mr. Chair. If I may, I'd like to make a statement first, and then I have a question. Okay, it must be me. I'm electrifying. Okay. Really. Okay, I won't get too close. All right. Doesn't like me. One thing I want to say is that I have never in my 3 years of being a legislator had an issue that I've agonized more over than this, because I see so much of both sides, and I agree with both sides to a certain extent. Personally, I had a child who was 9 years old when he was diagnosed with cancer, and so he was out of school for probably 6 months, and he had to be homeschooled and schooled in the hospital. But his immune system was certainly compromised then for several years afterwards. So I see that from that point of view. I also had an aunt who was not immunized, and when she was 2 years old, she contracted measles and chickenpox at the same time and went deaf for her entire life. So I understand how that works. So I guess, I want you to know that most of us up here are really trying to see all points to the issue, and really understand how we can make it better. And I guess like some laws, we'll be successful if neither side is happy. That's just kind of the way things go up here, where we come to some kind of a compromise. But I have a question for the panel, because several of you said that that people have to take a day off from work. Now, it's been my experience, anyway, in my health department in Oakland County, that they have accommodated, they've made some other special accommodations, maybe had evening appointments and and I have heard that there are other health departments that have made other accommodations so that parents do not have to take a full day off from work. And I'm just wondering if you are aware of any of those places that have done that.
Mr. Chairman, if I may respond. That's not been my experience. Parents have contacted me because they have...
Here in Michigan?
Here in Michigan, because they have had to take the day off of work. And then I've also seen videotape and heard audio of parents being bullied because the local health department employee will not accept their religious objection as valid and wants to argue their religious doctrine and their religious
I'm more
beliefs with
interested
them.
in knowing more about the accommodations, if there's been some accommodating in trying to make it possible and make it easier for people to come in for the educational piece. So, there's going to be the occasional employees, perhaps, that are overzealous or something. I guess there's no way we can legislate that.
Oakland County and some of the more populous counties have more resources, and they probably can do a better job of accommodating people, but it still requires a couple of hours that you have to make arrangements. And originally in Oakland County, they required us to bring our child and our insurance card, as though they were somehow going to convince us on the spot.
Right?
It took several months and a lot of commission meetings, but that did change. If you live up north, or you live, in the north of Midland and some other areas, you do have to travel significant distances oftentimes to go to your county health department. So I think the experience around Michigan is different. Kent County and Oakland County would probably, not be the experience of someone who lives in Midland, perchance, or north of Midland and has to travel, longer distances.
Well, maybe as these health departments coordinate what they do statewide, perhaps that's something that we'll see more of, where they'll make additional accommodations. So I was just wondering if you knew of that, because I'm aware that several of them are really doing the best they can to accommodate people schedule. So thank you, Mr. Chair. Thank you.
The other issue that does occur is if you have more than one child, for example, let's say you have twins, you obviously have to accommodate them. But if you have a child that's in preschool, you have to go successive years, which none of us quite understand why you're going year after year and hearing the same information. But that is some of what's done.
Okay, thank you. And thank you for the response. And I think there are things that need to be tweaked, obviously. There's things that I think we should really change, and that's a point that, makes sense to me. So thank you very much.
Representative Alexander.
Thank you. I have the immunization waiver in front of me. And I would just like to ask the panel if they have any insight to a story that's similar to mine as a county commissioner who chaired Human Services. I had constituents tell me of incidences where they took this document, they crossed out the section that offered that as you referred to, you made mention, you called it an incrimination statement, simply stating that you are placing your child at risk. They crossed that out, they initialed it to show that that was their intent of eliminating that portion of it, signed the waiver, and then the school would not accept it, or it was then not an acceptable document. So in other words, they were willing to do what they needed to do, go to the health department, go through the educational process. They looked at the document, and they just couldn't go with that portion. Do you have any examples or experiences of that nature?
Well, I can tell you that I received many, many calls about this document. A third of the people who actually signed this consulted an attorney or even brought an attorney with them. They were so concerned about the implications of signing that incriminating document. And you are told, at least I was told when I went and received a waiver for my preschooler, that you cannot alter the document in any way. You cannot say you signed it under duress. You cannot cross out a word. You cannot, some people, I don't even know what it means, VC, but there's some Latin, I guess, VC is the equivalent of under duress. And they were told they could not get those certified by the health department in the first place. So there were many, many people who found it very disconcerting and did not, could not alter that document in any form.
I too have received a number of those calls from parents who had issue with that language. They were concerned that it might be used against them in a divorce proceeding or a custody proceeding. It may be used against them in a child protective services matter, that they're somehow being forced to acknowledge that they're engaging in a behavior that would be putting their child or others at risk. They were very concerned about that, and I have yet to hear anybody ever tell me that they were allowed to make any modification at all on that form. The health departments will not let them do that. I don't know if that's coming from DHHS or if it's just a coincidence or maybe, I don't know, but I have yet to hear any parent coming to me saying they were allowed to do that. They ask me that all the time. Can I cross that out? Can I add my own statement? They won't allow it.
Representative Hornberger.
Thank you. I have a question, and then I have a comment. Thank you. If a child is not vaccinated, is that a guarantee that they're going to contract a disease?
No.
Okay, so my question is, as an educator looking at this as from an educator's perspective, and as a parent from a parent's perspective, and I think it's been lost in this process. We have students that are asymptomatic that are being kept out of school for 21 days or longer. If my understanding is correct, we could have a student that's kept out of school for 21 days because they haven't been vaccinated. Another student 3 classrooms down has contracted chickenpox, and 3 weeks later, they come back to school, another kid has the measles or has whooping cough or something else, and they're missing exorbitant amounts of time in school. And as educators and sitting on this education committee, our goal should be to have all of our students in the classroom every day, especially if they're healthy. I can understand sending a symptomatic child home, but if we're keeping students out of school simply because they're not vaccinated and there's no guarantee that they would ever contract whatever the said disease is, then we're doing a complete disservice to that child. Even if they're a high-achieving student, 21 days of school is an exorbitant amount of time. And you can't, as a teacher, I know, and I will speak to, and you can disagree with me, you can't say that a district providing a homeschool opportunity at that point is the same as a student being in the classroom receiving instruction from their teachers.
There's no assurance that a vaccinated child won't contract the illness.
And that was my question earlier.
There is a significant percentage of vaccinated children who never obtain any immunity.
The point
So,
that,
I mean, it goes both ways.
if I can just add, it's, we've been talking, yes, you still legally have the right to exercise your exemption. The problem is as a practical matter, I have parents calling me in tears. Once you exercise that right, if it's untenable to keep that right because your child is being excluded from school, even children with medical waivers get excluded from school because of this Rule Sub 4. So, yes, there is the concern, but the concern doesn't lead us to say we close the school down for one case of chickenpox because we're worried about it. The problem is that it's coercive, and it puts such a burden on the parents' right to exercise their waiver that it makes it, in the real world, it makes it very difficult to keep that right, because parents just simply will say, I give. I'm going to vaccinate my
One
child
last
to get him back
comment
to
is,
school.
all those children over this past year that have been excluded, I don't have statistics. I can only tell you anecdotally, I am not aware of any significant number of those children ever contracting the illness for which they were excluded.
And I understand.
So they're going home, they're perfectly healthy, and they go back to school 21 days later, healthy.
And I understand that when we're talking about any child can contract the chicken pox, whether they're vaccinated or not, we've established that. The argument that there are children in schools that have suppressed immunities. In all my years of teaching, I've had a few of those. It's not an exorbitant amount of students. Not saying that those students don't, deserve our best, as all students do. But I think when we're using that argument and it's being touted out there, you're making the argument like, as I'm hearing it, that there are all these immune suppressed students in our schools. And as a teacher for 20 years in elementary and 2.5 in high school, middle school, I did not experience that.
Well, the fact of the matter is,
I don't know if you have data on
70%,
that.
well, 70% of the U.S. population is not vaccinated for all these diseases. So immune-compromised children are not only exposed to other children, but they're exposed to the rest of the people in the world. I mean, they go to the movie theater, and there's adults there. There's people from other countries that are visiting us. I mean, the measles that occurred in California was brought in, we are told, I think by Chinese family visiting Disneyland. I mean, those things happen.
And just on a personal note, I was ground zero patient in 1990 at Michigan State for the measles. No one knew where I got it.
Okay.
No one knew how I contracted it. They did numerous interviews.
Yeah,
and it
I'm
ended
sure
up
it's hard to
being
determine.
50 other students that had classes with me ended up getting the measles. And from what I was told, everyone was immunized.
Right. Okay.
Thank you for your testimony. Appreciate it. We're going to start some comment cards. I'd remind you that you're going to have 1 minute, and I'm going to be timing on my iPhone here. First, if we could, thank you again. Testimony. Appreciate it. We're first going to start with Brigitte McQuiston. Is Brigitte in the room?
Maybe we may tell who's going to come up next.
And next would be Rebecca Heiser. Brigitte, I appreciate your attendance today, and I apologize that we're going to limit your comments to a minute.
I'll get through as much as I can. I've
Thank you.
submitted a packet with documentation for everything that I'm going to tell you about this morning. I'm from Lake Orion. I'm a registered nurse, and I also serve on the Lake Orion Community Schools Board of Education. I'm here to tell you about the experience Lake Orion High School had in 2015 when we had one confirmed case of chickenpox. The Oakland County Health Department was notified of this confirmed case, and an email was sent to parents of the students that had classes with this ill student. That was on Friday. On Monday morning, the Oakland County Health Department notified our high school that they would need to determine who among the classmates had been exposed. This student was also on the track team, so all of those students would also need to be vetted. The Oakland County Health Department emailed a script on Monday morning for the administration to use when calling parents to notify them of the expectation for them to get their child's immunization status updated or to be excluded from school for 21 days post-exposure. In the end, Lake Orion High School was forced to exclude 3 healthy students from school for 3 weeks and provide homebound educational services to them due to the Oakland County Health Department's student exclusion mandate. The other parents were compelled to get their child vaccinated in this situation. With proof of vaccination, 26 students were permitted to return to school. I've provided documentation showing the JCAR that shows the overreach of this as a high cost to the district. So I hope you'll look at our documentation. Thank you for your time.
Rebecca Heiser. Hi, Rebecca.
Good morning. I'm a pediatrician from Grand Rapids. I am not anti-vaccine, but I am pro-scientific evidence-based medicine and pro-parent choice for vaccines. For a child to receive other medical interventions, it's a standard of care that parents give informed consent. This should not exclude vaccines, and vaccines should not be mandatory. I personally have extensively researched vaccines, including their ingredients and safety, on my own because these topics are barely addressed in medical school or residency. From my experience, most pediatricians have not done this type of research, and I believe many are not very aware of controversial ingredients and relevant safety concerns. In medical training, teaching on vaccine safety basically seems to consist of a proclamation that vaccines are safe. There's also great pressure from the medical community for doctors to not raise safety concerns. The majority of parents I've encountered who want to delay or defer vaccines have put much thought into weighing out the risks and the benefits. These parents have often done considerable research on vaccines, and many know much more about details of vaccine ingredients than many physicians. Research shows that many parents who decline or defer vaccines are highly educated and of high socioeconomic level. These parents are not in need of forced education by the state.
Thank you. Dr. Eden Wells, Michigan Department of Health and Human Services. Thank you.
Thank you all very much. I appreciate the opportunity to be here today. I did hear some inaccuracies. I won't have the time to address those. I do want to approach the fact that there has been mentioned several times about a 24% decrease in the waiver rate prior to the initiation of the administrative rule that is current. That is due to the fact that there was already ongoing concerns about the waiver rates. Much work was going on with the local health departments, along with the change from the 6th to 7th grade rules that were done at that time to maximize vaccination. The current waiver education administrative rules directly align with the Public Health Code. They support the MDHHS Division of Immunization's goals. They do not remove parents' ability to sign an exemption for their child, and this has never been a one-sided conversation. With our current policy, we have a balance between the competing values of the individual liberties of the parent and that of the common good of public health policy. And in fact, Michigan remains the top 1/3 of states in this country as far as parental rights on this matter.
Doctor, may I, thank you.
Sure.
May I ask you what changed, what prior to 2015, we were going along, we had this statute. What compelled you in 2015 to change or promulgate a different rule, different practice than what we did before?
The increase in waiver rates has been a national issue, but particularly this state was actually ranked probably in the very top 5 of states that had highest waiver rates. This rule was implemented so that you can maximize the understanding on a patient or on parents the educational risks and benefits for taking a waiver on vaccination. And in fact, since then, our waiver rate has decreased 33%. There was not an increase last year. If you count 0.01% increase, a statistically significant increase.
Thank you very much.
Mm-hmm. You bet. Do I have any remaining 30 seconds?
I'll give you 30 seconds.
Oh, good. Sorry, and I really do appreciate it. I know you all, this is a very important topic, as you know. I just wanted to say that on the matter of exclusion, exclusion has been used since 1904 as a public health norm across this country. This has been proven in statute, as we have mentioned previously. This is a norm. This is something that I think we'd be very concerned if this state did not utilize this tool. It is the most important tool to protect students. Again, we never know when somebody's immunized, whether they'll get disease or whether they're not. However, if we were to take this position, if this step were to be taken regarding the tool of exclusion, we would be not only the only state in the country, but this would reverberate negatively on this state through the CDC, through the Federal Department of Health and Human Services, and the World Health Organization. And I would not want to be part of that system.
Thank you, Doctor.
So are you talking about exclusion of a healthy person?
Absolutely. Somebody who is, well, if they're not well, they should not be in the school. If a person is unvaccinated or at risk for the communicable disease in question, let's take measles. Okay? There's a case of measles, there's a chance they were exposed. Here's the problem. When they're exposed, they may actually become infected, spread the disease before they even develop symptoms. So that's why we hold these students out for the 3 weeks, what we call the incubation period.
Correct, but that could happen with any student. Even a student that's vaccinated can contract chickenpox and spread it
One.
While we don't know-
First
before
off,
we know
is that
they
would be a
have it.
highly, that would be a disease that would be highly modified, less likely to cause complications. What we're trying to do is protect the students who have been exposed to that person who are not protected, and those children around who cannot be vaccinated.
Thanks. Thank you for your testimony. Go at ease. We have, a lot of people have come a long way to speak today. We've run out of time for the day. I am going to come back here after session, and any other members of the committee who wish to join me, to take testimony, further testimony, and give you, everyone here that wanted to speak, an opportunity to speak. So we're going to go at ease here until after session, which would likely be 2:30. I know many of you can't stay around, but I will be here in this room as soon as session ends, and be over here and be able to take your testimony of those who have come a long way and wish to remain here and speak. So I thank you again for your attendance today. I thank you for your patience, and we'll go at ease, call the chair. Thank you.